Welcome to the I Got Fired podcast, where we help folks who've been fired or afraid that they might be. I'm Tom Spiegel, founder of the Spiegel Law Firm. We represent clients in Maryland, Washington, D.C., and Virginia. And today we're going to be talking about when you have a dispute with your employer. When does that become public? When can, say, for instance, your next prospective employer look it up on the internet and find out that you had a dispute with your former employer, which is obviously a concern for a lot of people. But first, a little fine print. This podcast is for educational purposes. It's not intended for as legal advice for your specific case. If you want specific advice for your case, then you got it. You need to go hire a lawyer. So with that said, let's talk about the public nature or not public nature of employment disputes. Understandably, a lot of people, particularly professionals and high-income folks, are very concerned about, they don't want to be known as that person that sues, right? They don't want to be splashed on the front page of the Washington Post or local paper that they had a dispute or a lawsuit with their former employer. So in terms of when that becomes public, the short answer is it's not, unless you file a lawsuit, right? Unless you, probably through a lawyer or on your own, but probably through a lawyer, go down to the courthouse and file a complaint. That is public record. Anybody can look that up. If it's in the federal system, if you're in federal court, as many employment cases are, then that's on something called PACER, P-A-C-E-R, and anybody with that account can look it up, and it can be on other sites as well. So once you file a complaint, either in state or federal court, then anybody's going to be able to find it. Now, in some state courts, they're not public record, but they're not online yet in the sense you can go and search those complaints. So in those instances, somebody would have to go down to the courthouse or do some other digging to find that document. But that's not particularly difficult. But nevertheless, if it's not online, somebody, the HR department of your next job is unlikely to go down to the courthouse and some small county to see whether or not you filed a lawsuit. But the safe assumption is if you're going to file a lawsuit, then anybody's going to be able to find that. But there's a lot that happens before a lawsuit that is not public. So, for instance, in I was advising a high-level executive a couple of weeks ago, and one of her concerns was that, look, this is happening to me at work. I think this is wrong, and I agreed with her that it was wrong and potentially illegal. But I don't want this to be. I don't want this to be public, right? I've got a career to protect. I don't want to be the one who sues. And what I explained to her, what I'll explain to you guys now, is that, look, a lot of this is under the radar screen. Most cases are resolved before you ever get to court. And the things that you do prior to going to court are with a rare exceptions, not public record, in the sense that somebody can go to Google and type in your name and it will pull up, your dispute with your employer. So, for instance, one of the first things that happens in an employment dispute is, particularly if it's private sector, you don't work for the federal government, is that you send something called a demand letter to your former employer, where you set, either you or through your attorney, you kind of state what happened and why you think it's illegal and what your ask is, whether it's money or a release from a non-compete or whatever your ask may be, usually called a demand letter. Those are private communications. Of course, anybody, this is true anytime, anybody could, can go and tell people your business, and that's always a possibility. But I've rarely seen that happen. So sending that letter to your employer is not public record. Nobody's going to be able to type it in on the internet and look it up unless, you're a really famous person and some site gets a hold of it and publishes it. But most of us don't have that burden. So you sending a letter to your private employer is not going to be something that somebody outside of a small circle of people are ever going to find out about. And so what happens after that? There's often going to be some back and forth with your current or former employer and you and your attorney. and the matter could get resolved there. And let me say also, all through this process, you as the employee are not the only one who has concerns about what becomes public. Your employer doesn't want this to be public, right? They've got skin in the game too. Let's say that you are, you feel you're newly pregnant and you feel like you are the subject of pregnancy discrimination at your workplace, and you send a letter to that effect through your attorney, let's say to your employer. Well, your employer doesn't want that out there, right? Well, even if they think they could beat that particular allegation, they don't want to be the one, on the newspaper as being accused of pregnancy discrimination. Not really good for recruiting and retention. So both sides have a lot of skin in the game to not talk about this. So you've sent the demand letter. Let's say there's some back and forth with your attorney. None of that is public record. The chances are that nobody's ever going to find out about it. Also, when cases are resolved, this is usually true at any point, but this is particularly true prior to filing a lawsuit, they're going to include the severance agreement, or the settlement agreement is going to include some clause where both sides agree not to talk about it, right? Because again, the employer doesn't want its business out there on the street about these allegations, and you don't want it out there either. So ideally, it's called usually it will be called a non-disparagement clause that basically says, "Hey, I agree, not to talk about this dispute again because the employer doesn't want it out there, just like you don't." And one thing you want to do is, if you can, make sure that non-disparagement clause is what we call mutual. Right, that both sides are bound by it, so that the employer agrees that it also will not talk about the dispute if somebody contacts the employer, let's say, for a reference in the future. And sometimes as part of that process, you can even reach an agreement with your former employer about what they're going to say and who's going to say it. So a lot of times it'll say, future references will be directed to so-and-so at HR. And you can agree upon the language what the reference is going to be, or at least that the reference will be neutral, essentially, name, rank, and serial number. Hey, she worked here from this date to that date, and she had these titles, and then that's it, essentially the end of the neutral reference. And some employers do that anyway, even without a dispute, because they don't want to be subject to a potential defamation claim, so just to protect themselves that they do that. But nevertheless, whenever the dispute is resolved, and 99.9% of the cases, there's going to be that non-disparagement clause, because everybody wants to keep this hush-hush. It's in nobody's interest to have this on the front pages on the newspaper or even available on Google. So again, the vast majority of employment disputes are resolved well before a lawsuit. and are going to involve this non-disparagement agreement, and where it does not become public. But let's back up even a little bit. And let's say that you are, you've sent the letter to your employer through your attorney, and you're not able to reach some kind of resolution, and you got to push this matter a little bit further. In many cases, not all employment cases, but in many cases, the next step is to file with an administrative agency. That's usually the Equal Employment Opportunity Commission, or EEOC. You can find their site at eeoc.gov. And that's often a prerequisite to filing a case in court. You have to, again, not all, but many employment cases, particularly if they're discrimination, you have to file it with the EEOC before you can go to court. It's called filing a charge. Again, it's an official document. It feels, somebody's probably not been through this, perhaps like you're filing in court, but you're not. It's an administrative agency, and it's the step that you have to take before you have to file a lawsuit. So even though you are submitting this formal charge document through the EEOC's website or through fax or however it is that you file it with them, this is not public record. Nobody's going to be able to, type up on Google whether or not you filed an EEOC charge. And pull that up. A prospective employer is, again, if your case doesn't go to court, your prospective employer is never going to know that you filed with the EEOC. And again, many cases are resolved or wash out at the EEOC level. The EEOC does have mediation. It's not mandatory, but and just if you're interested in mediation, I did a whole series of podcasts about the topic, and you should go back and check those out. And I did one specifically on the EEOC. But in any event, there's an opportunity to get the case resolved either through mediation or again through the continuous back and forth with your employer to resolve it at that level. And if you do, again, unless somebody goes rogue and goes out and tells people, and frankly, I understand that this is a big step for most people, and I'm not saying that it's not serious. It is. It is a serious matter, and for most people, it could, be one of the things like selling a house or getting married that they remember for the rest of their life. But, for the rest of the world, the fact that you filed, a discrimination complaint, the Washington Post, the New York Times, Fox News, they're except in very rare circumstances, they're not going to care. So the fact that somebody's out there talking about this, the chances that anybody's going to, take that, amplify that are slim, unless, again, you're a famous person or somehow very high level, or there's something particularly salacious about the case. But 99% of people, that's not the case. So if you file at the EEOC, nobody's going to know that you filed that charge, particularly if you get the case resolved. And even on the off chance that somebody goes off and tells somebody else, those embers are going to die out. This is not going to start a professional fire for you. So again, and we're talking months, in rare cases, even years that this process can take. So, let's say you go hire an attorney or you send a letter yourself, and there's some back and forth. That process alone can take a number of months. You file at the EEOC. You have to give them at least 180 days to do the investigation. They rarely complete an investigation, and I say investigation lightly because it's not like they really go out and turn over a bunch of stones for you. But nevertheless, you've got to give them 180 days, so it's going to take at least that long. And then mediation can occur anytime during that point, but that's going to take a little bit. So it's not like this is going to happen quickly. So you're going to have a while where you're having a back and forth with your employer that is not in any way public. And if you get the case resolved, again, there's going to be a non-disparagement agreement, and nobody is going to be the wiser. And that's how most cases are resolved. So for most of you out there, I think it's sometimes this idea of something going public even stops people from seeing a lawyer. Don't. Go see a lawyer, go educate yourself. There are a lot of things you can do to stand up for yourself that don't involve your business being, put on Pacer or otherwise subject to an internet search. And keep in mind also that you as the employee, again, assuming let's say it's a discrimination matter or something that you are affirmatively pursuing, you as the employee have total control about where this goes. Your employer, again, except in very rare circumstances, is not going to have an opportunity to say, well, you know what, I'm going to sue you. And sometimes that happens, but it's pretty rare. And even when those threats are made, it's usually saber rattling because, again, they don't want to make this public either. So in the vast majority of cases, you as the employee are in control of the throttle of your case and how quickly it goes. So at any point, you don't want to pursue it, then you can stop pursuing it. If you file the charge and you get what's called a right to sue, which is the end of the EEOC process for most people, where the EEOC essentially throws up his hands and says, hey, we can't say whether or not there was a violation of law, or we're not making a decision here, but we're going to close this matter. Here's your right to sue, which is your ticket to sue. Again, not a public record. Let's say you follow that process, you're unable to resolve it with your employer, you can let it go. If being public record is something that's going to really affect your career, it may just not be worth it. And hopefully you've got a lawyer or somebody that you're working with that can help you think through this. But if you decide not to pursue it, then you can take your foot off the gas at any point, and then the case is over. And then, of course, if you get what we hope for, a resolution that gets you to a better place, that gets you some money, that gets you a positive reference, that gets you, any number of things that you might want. Again, you might want to check out our legal leverage program, where we walk through some of these some of these strategy issues, you can find it on our website. But you have complete control. So you can decide whether or not you're going to file it in court. And again, you've got some months before you do this. And, so then you've got a choice. We file complaints probably almost every week in my law firm. So there are people, that it makes sense to do this. The issue is important enough. And hey, look, here's the other thing to consider. Of course, nobody wants to go through a lawsuit. Nobody wants to necessarily be subject to a Google search that way. But this is a way we resolve disputes in our country. And I think people understand, particularly if you're subject to egregious sexual harassment, and your employer doesn't do the right thing, your employer won't settle with you, who is going to blame you for pursuing that in court? And remember, when you file the complaint, you throw the first stone in this instance. That's your story. You lay it out there, right? You can't, it would be unethical to lie, and I don't think people do that, but you get to set forth your version of what happened within reason, with as much detail as you want. So if you want to file a 100-page complaint that sets that out there, then there's nothing stopping you from doing that. Most complaints don't need to be that long. But the point is the first thing that's going to hit public record, the first thing that people are going to see is going to be your version of events of what happens. And there are any number of, right, people at really high levels, they're used to, they are not a stranger to this. There are all kinds, companies suing each other, executives suing each other. It's just a part of doing business at that level. So we see it in the news. So the fact that you file a lawsuit, particularly if it is, you have really been harmed, and that's pretty obvious, then is that going to end your career? Probably not, right? People understand you have to stand up for yourself. We saw it happen, in the Me Too movement. The next employer, your next employer, the hiring manager may have experienced the very same thing. And, and you'll, not only will you not be frozen out of that position, but it may actually end up being a good thing. But obviously, these are kind of issues you need to weigh out with whoever is advising you. And if you're thinking about filing a lawsuit, with your attorney, and keeping in mind when you're negotiating, the company doesn't want this out there either. Because again, for them, it's going to be the complaint that is the first thing in that record, which is your side of the story. Yes, the employer can answer, it's called filing an answer, which is the legal response to the complaint. But that's often perfunctory. Most of the times it's just, admit, deny. The company can put out its version of the story too. And if it's a high profile, matter, they may put some more text in there. So it's not that you're not going to take any slings and arrows. So there is that response, but it's usually not as comprehensive as the complaint. And again, it's the second piece of what comes out. And then there are a lot of things that happen in that process after you file the complaint that are not public record. In many cases are resolved before they get to trial. So it's not, in most instances, going to be the end of your career if you end up filing a complaint. But remember that the vast majority of cases are resolved, many of them successfully and then in a satisfactory manner to the employee, are solved well before you get to court. So whatever resolution there is, nobody's going to know about it. The final agreement goes into your electronic file on your computer and your employer's electronic file, and that's where it goes to die, because nobody wants to revisit this, and you go on with your life. And the employer goes on with its business, and everybody just continues on. So, of course, it is a concern for people. You often, all things being equal, don't want things to be a matter of public record, but there are, in most employment disputes, the pre-lawsuit interactions with your employer are not going to be public record. And many times cases are resolved at that level. So don't let that stop you from at least going to talk to a lawyer or pursuing your options. If you really, if you've been wronged, you need to have some avenues, or at least know that you have some options, and don't let the thought that, well, this is going to be public record if I send a letter to my employer and everybody's going to know about it, because in the vast majority of cases, that's just not true. So I hope that's helpful. If you want some more information along these lines, I highly recommend you check out our site, thecareerrocket.io, where we present the latest and greatest on employment law and other tips and tricks for how to keep your case on an upward trajectory. So until next time, I hope you guys found that helpful. Take care.